Hi, good evening. I'm Lonnie Stonich, the Executive Director of FAN, and let's start over. I'm honored to welcome you to tonight's conversation between Laura Coates and Emily Bazelon. Thanks for attending. FAN is a nonprofit organization that presents a high-quality speaker series offered free to the public on a wide variety of topics, including human development, mental health, education, and social justice, among others. We have over 175 videos of past events archived on our website and on our YouTube channel, so please be sure to explore. For introductions, we have Laura Coates is a CNN senior legal analyst, Sirius XM host, and adjunct professor at the George Washington University School of Law. She is author of the powerful, brilliant new memoir, best-selling new memoir, Just Pursuit, A Black Prosecutor's Fight for Fairness. A former federal prosecutor, Coates served as Assistant U.S. Attorney for the District of Columbia and a trial attorney in the Civil Rights Division of the Department of Justice, specializing in the enforcement of voting rights throughout the United States. The stories I bet she could tell. As a civil rights attorney, she traveled throughout the nation supervising local and national elections and led investigations into allegations of unconstitutional voting practices. Emily Bazelon is a staff writer at the New York Times Magazine, the Truman Capote Fellow for Creative Writing and Law, and a lecturer at Yale Law School. She is the author of Charged, the New Movement to Transform American Prosecution and End Mass Incarceration. Her previous book is the national bestseller Sticks and Stones, Defeating the Culture of Bullying and Rediscovering the Power of Character and Empathy. We're proud to have hosted Emily for both of those book launches. She's also a host of the popular weekly podcast, The Slate Political Gabfest. And now let's welcome Laura Coates and Emily Bazelon.
Thank you so much, Lonnie, for that super introduction. Laura, congratulations on this excellent and rich and really candid account of your years as a prosecutor. The book is full of, you're welcome. It's really a pleasure to be here with you. The book is full of storytelling, and I want to give you a chance to dig into one of those stories or more of those stories. But I also wanted to start by setting the table a little bit. So you went to work for the Department of Justice originally in the voting rights section of the Civil Rights Division, which is the kind of job where you're trying to figure out, are localities unfairly closing polling places? Is there other activity going on that could be creating racial disparities and access to voting, other kinds of problems, people for whom English is a second language? And then you write in your introduction that you started getting a little bit of frustrated with this work and you decided to try going to work at the U.S. Attorney's Office as a prosecutor. So you say that the transition from enforcing civil rights legislation to criminal prosecution represented a seismic shift in how others perceived me and even how I perceived myself. I had been a trusted champion of people who looked like me, but now I was often distrusted as an agent of a system that disproportionately filled prisons with people who looked like me. This created a struggle, an internal battle of allegiance between the competing facets of my identity. It wasn't always clear which should win. For 7 years, I upheld my oath as a public servant, but my work put me at odds with my principles and lived experience as a Black woman. So I just thought that was such a strong and deep way to start your book. And I want to put you on the spot a little bit by asking you to reflect on that sense of being beholden or obligated to uphold this competing sense of values, and just ask you to reflect a little bit on what that was like as you were starting this new job.
Well, first, Emily, I'm so glad you asked that question, and also the opportunity to converse with you all, because it's so impactful to me to have the opportunity to really hear and talk about the book more and more, because it's so personal, so vulnerable. And it's really something I think people did not expect me to write. They thought maybe a law school textbook that you could have a Socratic method response to it in some way. But I was intentional about really confronting that really introspective part of myself and thinking about how, frankly, I never had the luxury, nor do I think I ever wanted the luxury, to enter a room and shed the different facets of my identity. I walk into rooms, whether it's a boardroom or a classroom or a courtroom or on a media panel. I walk in as a Black woman, as a mother, as a wife, as somebody who is a student of history, as somebody who has the lived experience of a Black woman. And oftentimes my moral compass would point one direction and the director would point a different direction. And I had trouble sometimes reconciling the two. And so I talked about how, frankly, when I first began in law, I was in private practice where, I had personal clients, I had corporations represented, and I had a calling to go into the civil rights division. Frankly, the idea of going to the voting section was something that was a profound sense of pride and joy, because I'd written my senior thesis in college about the idea of restoring voting rights for former felons. And you can imagine how that went over in a Bush Department of Justice initially when I interviewed. But I was even then not realizing the extent to which I would be challenged on what I believed and what I was ordered to do. And, when you're a civil rights attorney, it's a foregone conclusion, Emily, on whose side you're on, right? For whom you are a champion. The idea of people who look like you, people who are most impacted by the voting rights cases across this country. But as you can imagine, even at the time when you had Section 5, when you had the preclearance, when you still had not a yet rendered anemic Section 2 of the Voting Rights Act, it was still bureaucratic even in that juncture, because the perception you have to guard against for politicians to interest groups is that you're not engaged in a political act. And we were not, but there was a lot of almost contemplation to the point of bureaucratic paralysis. And I felt like I wanted to have a more impactful, tangible difference. And I thought that the venue or the vehicle for doing that was with the U.S. Attorney's Office. But as I wrote, what an absolute seismic shift to go from the foregone conclusion of the people's champion to looking as if I had, to some, betrayed the very people who were Black and brown victims as well. But because I was now standing where it was presumed the stereotypical white man, the man would be, I was perceived differently, even under that same umbrella of the Department of Justice. And I think I failed to appreciate what that shift would look like and how it would really force me to confront aspects of our system that I'm not sure I ever thought I'd have to.
So you start the book with a kind of amazing story that I think illustrates some of what you're getting to. It's a story about a man named Manuel who was the victim of a crime and who came to your attention in that capacity. Could you tell us that story and how you came to think about it?
I really begin the book talking about how the pursuit of justice can create injustice. And I think when you read that, you think, well, how can that be? You're pursuing justice. So whatever happens along the way was sort of the end justifying the means. But in reality, I start with this story. And in my commentary, I don't suffer any fools. And I did not want to leave myself out of the scrutiny. I wanted to, in my introspection, I was not attempting to self-aggrandize myself as an attorney. I wanted people to know the truth and what pursuing justice actually looks like, not just what the law is, how it's interpreted, but how it feels. And this was a case where it was a car theft by a man who was a repeat offender of a number of different instances, somebody whom society would want to hold accountable for the litany of things that he had done. And the person's car he stole was an undocumented person who would come to the country decades ago as a teenager and had not so much as even sneezed in the direction of a police officer since then. He was raising his family, he was gainfully employed, and he was the victim. It was his car that was stolen. And so he did what we want people to do. He reported the crime. And when he did so, in preparing for trial, which was a case I had inherited, I ran a background check, which I do for every person who might come into a courtroom, because we need to alert the marshals of any safety concerns or a warrant, for example. And in his instance, it pinged an active deportation warrant. And the policy is any active warrant, of course, gets revealed and disclosed, and then the machines of the powers that be continue. Well, in this quest to pursue justice in the form of this binary conviction or acquittal of the person who'd committed the crime of stealing a car, here I was trying to reconcile this unfairness, this injustice of somebody who we want to be able to report crimes. As a private litigator, I had private clients, I had corporations. As a prosecutor, I represent the people of the United States. And we don't have the individual victim as our sole concern. It's for the future victims, to avoid future victims. And yet there was this choice that had to be made between somebody who was undocumented and whether to report and risk their own deportation, which helps society to have their crime reported, or to remain in the shadows, so to speak, and be exploited or victimized in other ways. And I tried to figure out a way that I could avoid the injustice. Some colleagues said, Coates, tell them to run. Don't have this on your conscience. Others said, well, you'll face disbarment if you're aiding and abetting somebody with an active warrant. Others said, well, what do you care? He doesn't have clean hands, so to speak, because he was illegally in this country. And for me, it was one of those instances where my moral compass of what was right and fair was this way, and what was ordered was another. And I was faced with the dilemma of, when all alternatives had been exhausted, to then assist in his deportation, handing him over to agents. And then in that moment, having to become his personal advocate, trying to figure out what rights he had, how I could ensure that his family knew where he was. And I got to tell you, in those moments, I often think to myself, and I don't want to suggest in any way that my personal turmoil or feelings at all matches what this man was feeling. The scream of his wife alone on the call, I knew that this was not something to which I should be focused on. But yet, without alternatives and what I was left to do, that to me is one of the instances where you're pursuing this conviction where the end would not justify the means of what would have to happen to this person. And imagine if it wasn't a car theft victim, Emily. Imagine this is somebody who was a sexual assault victim or somebody who was killed by another. Do we want a society where the choice is remain in the shadows and continue to be exploited, or come forward as society behooves you to do? And in that position, I felt quite powerless with all the power I had. And I wanted people to understand what that looks like.
Yeah, I mean, it's quite a story to tell on yourself. I mean, it really does give the book this sense that you are not going to like pretend to be standing outside the system or not implicated in your criticisms of it. And I mean, I was struck when I was reading by the reality that if people who are victims of crimes then have to fear deportation, which was this like very looming reality for this victim, that of course makes them much less likely to report crimes. And so I think that's, you know, a discussion that some local district attorneys' offices had with ICE during the Trump administration to try to keep ICE out of the courthouse. But you were on the federal side of this state federal prosecution divide, and you were following this policy. And I think I guess, did you feel like you had a real choice?
You know, I did have a choice, but not one without consequences. And I think that's part of the dilemma that we often think about. It's never either or. Certainly there is acts of civil disobedience one could engage in, but the consequences to you personally are going to be quite severe. And in realizing that, the idea of the cost benefit analysis of how we approach justice, the idea of the prioritizing of who is entitled to be a victim, the idea of sort of sometimes the lies we tell ourselves to ensure that you feel good about the job you're doing, and in the end can excuse your own complicit role. And I tell you, I still grapple with that day. I still grapple with the choices, even knowing that legally there was but one choice, but morally, in the pursuit of justice, we ought to have more. And it's for the reasons that I've articulated that I think so often we forget about, that there, you know, it's almost like that the John Lennon quote of life is what happens when you're busy making other plans. Well, I mean, injustice can occur when you're busy pursuing it. And it's this idea that you don't think about, you don't realize, you know, emotionally and realistically and pragmatically, the way in which our justice system is often at odds with our policy considerations. And what are we going to do about it?
Yeah, that's really well said. I mean, one other thing I thought when I was reading this chapter was that I think of prosecutors as having a lot of discretion.
Mm-hmm.
And this whole question of whether prosecutorial discretion is good because it can introduce some case-by-case analysis and kind of wiggle room and sometimes mercy into the law, or whether it's also bad because it can make prosecutors who have preconceived notions about a particular group of people or a defendant, you know, based on race or class or age or gender, put their thumb on the scale in a way that's not actually a kind of equal delivery of justice. And so I was wondering if how you've come to think about prosecutorial discretion and whether there's a story in your book that kind of illustrates what it is like to have discretion and to really have to weigh what to do when you have, I think, what's a more sort of full choice than you had in the story about Manuel.
Well, you know, it's interesting because you think about, most people believe because you've got an attorney general and think about the org chart of the Department of Justice, think about the US attorney, and they think because of the way that maybe Law and Order or the CSI effect, or maybe even the major headlines, that you think that everything gets run up the chain, as if Attorney General Garland is looking around right now and going through every single prosecutor's cases and saying, hey, does that look right? What do you want to do? Let's have a meeting about it. No, overwhelmingly, I would say 99.99999% of the cases are handled autonomously by an individual prosecutor who knows the office policy, but is exercising a tremendous amount of discretion. And with that comes the exercise of their judgment, which of course is informed by their preconceived notions, perhaps by their personal bias, even if it's not a conscious level of bias. It's informed by their own life experience. It's informed by what they perceive as their role within the justice system as well. And because of that exercise of discretion, really across the board, you're going to have, in some respects, a patchwork of approaches. You're going to have people, some who are doing it with honorable intentions, who are going to wield that power responsibly. You're going to have others who are going to wield that power reflexively and in an abusive way at times. And there's different chapters in the book where I think about the different stages where prosecutors have discretion. One is a book called The Chew, in the chapter about privilege in charging decisions and the ways in which some people believe that they themselves as individual perceived victims, whether they truly are or whether they have an axe to grind, are trying to enforce or get the prosecutor to be a bit of a puppet for them. You have the ideas and how race and privilege can go hand in hand with the charging decisions sometimes in an office of who to prioritize, because which is going to be the conceivable most squeakiest of wheels. Then you have instances when you have the exercise of discretion in terms of how you're going to try to create informants and opportunities for people to help you with your case. There's a chapter that talks about, it's called You Want to See Something Funny, and it's about a white male colleague of mine who thought that he was going to teach me how you are a prosecutor, how you interrogate people. And he came to my office to say, you know, and I had piles of files on my desk preparing for different trials. And he said, you want something funny, Coates? And in that moment, looking for levity, as a bit of escapism, which you all do, I said, well, sure, thinking that a punchline that he had would be one that actually made sense as humor. Instead, I found myself in the basement of our own building with a chained young Black male defendant with whom this particular colleague was trying to convert to a cooperator. And in that moment, looking at the way in which the discretion one would have to control the outcome, to try to buttress one's own case, was a form of discretion that I think exemplifies where we also can go wrong. But again, even my very presence can render me complicit in these moments, even for my best judgment to avoid it. Other instances include, you know, the ability to ask for a particular sentence. You know, in the news today has been a lot of conversation about the feeling of the family of Ahmaud Arbery down in Georgia, who has now learned about a federal plea that I understand has now been continued till Friday. But their horror that these two, father and son, were going to have the ability to have a plea, go to a federal prison as opposed to a state prison. And the idea of whether they were enveloped and informed and kept abreast of what was going on. Well, that's a level of discretion as well to exercise. The type of sentence you want to offer, the type of plea you want to offer to somebody, and trying to figure out what the appropriate range is. And, much to my perhaps naivete, I think everyone else's, no one's pulling you aside to say, hey, here is this crime equals this penalty equals these factors. Here's your formulaic approach to have uniformity, to have consistency. So it's not this sort of exercise of subjectivity. But in reality, that's exactly what happens. There's a range. Now, where do you fit in it? And how are you going to wield it? And so there are so many moments in the book where I talk about and think about those different stages where discretion is exercised, even in the non-traditional sense.
So, one of the really interesting aspects of the book is your discussions of the relationship that prosecutors have with victims. And related to what you were just discussing, one of the really important parts of that relationship is just keeping victims informed. I often feel like in my reporting that when victims are unhappy, that part of what they say is that they felt ignored, that nobody just kept them abreast of how a case was progressing. So you tell a story about you had an obligation to seek victim impact statements in some of your cases, and you tell a really interesting story about calling someone on the phone who'd been a victim who seemed to have said at first, I want nothing to do with this case, and then she wound up coming to court. And tell us, if you don't mind, what happened next.
Well, this is a chapter called I Want No Part of This. And it's one of those unexpected moments. The book really ebbs and flows and talks about moments of triumph and moments of extraordinary humanity, and also talks about the reality, which is sometimes the underbelly and the ugly side of justice as well, and the tragedy that can befall. But this was a chapter where I unexpectedly had a victim who went from not wanting any role to providing any statement, where you can go to the judge and say, look, I'm the person, I know you have the society that's impacted, but I'm the person whose car was stolen. I'm the person who had the violent crime done to them. And they can go and tell the judge, here's how it impacted my life. So you can give a sentence that is commensurate with what my experience is. And it can be up or down, depending on what you're saying. And normally you would think that people who have been victimized will say, throw the book at the person, right? That this person showed me no mercy. Why should I extend it to them? But this particular woman, when she learned the age of the person who had committed the crime, he was in his early 20s, a young Black man, she herself, an older Black woman who had raised sons. She said, I want to be there. I'll be there. And when she arrived at the course, I had no idea what she was going to say. They're not required to tell us what their thoughts are. I was prepared with my sentence recommendation nonetheless. And she began to just so eloquently talk about this notion of the intersection, frankly, of race and justice in America, and the idea of redemption being a part of the justice system, and what a second chance looks like to Black and brown people versus their white counterparts. And she was not prepared, nor would she play any role in looking at a man chained before her and continuing to contribute to him being chained in that way. And it was that one of those moments of extraordinary surprise where the judge, his jaw was, dangling, because so rarely do you have these extraordinary acts of compassion. And, but it also had an interesting twist that I talk about, in that as a prosecutor, talking about discretion, when you stand up and say on behalf of the people of the United States, that necessarily includes the defendant. And some have extraordinary defense counsel who are there to be their advocates. Others have less than stellar advocates and require an additional champion. And in the case where the victim impact statement provided a vehicle of that champion and had counsel, in those moments, sometimes prosecutors, I know myself in particular, would try to ensure that the credibility that you have before a judge to extend what they called an allocution, a sentence for a recommendation, and the reasons for it. At times, you have to think about which fight and which battle must I choose to ensure that I am providing the requisite level of lenience or severity or whatever it might be for my cases. Who requires a champion in this moment? And it's interesting to think about how frequently, in fact, justice comes down to these cost benefit analysis situations. When you think to yourself, you know, at some point, although the government is fungible, Emily, and you know that, you know, I remember there was times when I would say, oh, I'm sorry, Your Honor, this calendar date doesn't work. That's my due date for pregnancy. And they'd go, oh, is the government having a baby? Oh, the government's having a baby? Is that what's happening right now? Is the whole government having a child? And I'd be like, oh, I see how this is going to go right now. Okay. So no, the government's not having a baby. So you're telling me this trial. Okay, great. And they think of you as very fungible, like whoever can stand up for you. They call you the government half the time as opposed to your last name. And so because of that, prosecutors are very aware that they are the beneficiaries of what's done well, and they are not the beneficiaries of other mistakes that are made. And so you almost are always threading a very important needle about how much you're going to go rogue conceptually. And when you need to vary from those guidelines, which are the cases you're going to do that for? So that when you actually ask for it, when you're sitting and acting as an advocate, does the judge look at this as enough of an aberration that they take notice, or a continuation where they look and perceive you as sort of the Trojan horse of prosecutors?
Yeah. So in your description of this scene, as you're kind of balancing what you feel are your responsibilities to these different defendants and cases, it sounded like you decided not to ask for a break for the car thief because you felt like the victim had already kind of done that work for you. And then you were kind of holding on to your cards to play them in a different case. So I wondered what the two sentences that were received were, whether the victim succeeded. She was asking, I think I remember, for no jail or prison time and just probation. But if I recall correctly, it was a case in which there was an injury to an officer as well as stolen property. So I just wondered what happened.
Well, interesting in that case, of course, you know, when the victim has but a sliver of knowing what particular role they are playing. So for her, it was her car was stolen, and we should just, if that's all there is, then forget about it. I'm the one harmed. But there was a car chase. There was the issue of what was found in the car. There was the issue of other aspects that made, that there were certain factors that required the sentence to be firm. And even in that, the idea of not as from the victim standpoint and some in the courtroom, the idea of how could this victim impact statement not be disruptive enough of the domino effect of all the other actions that followed. But that's part of why the justice system is so complicated. And oftentimes it's a legal system trying to become a justice system, because that domino effect can be the impact for everything else, including that sentence. And there was leniency shown. There was, I believe, a combination sentence of the idea of sometimes you can have what's called a split sentence, where you can have certain time that you are serving in jail, and then the remainder of the time will be held over your head to give you an opportunity to have a second chance. And if you stay clean, keep your nose clean, then that time will just linger over your head like a sword of Damocles. And then, of course, you're able to wipe your hands of it. Now, of course, the reality is that sword of Damocles often falls. And when it falls, the severity of the sentence is felt almost immediately. And you'll have some people who will say to themselves, like, I remember thinking was so odd when I would hear someone, you'd ask the prosecutor for this split sentence, you know, this person went to 6 months or 1 week, and the rest of the time hung over their head. And they would say, nope, I just want straight time. And you'd go, who would ask for straight time? They're giving you a chance here. What are you talking about, straight time? But I quickly learned that, of course, you think about once the justice system, so to speak, has its claws, once you're under the microscope of the justice system, it is very, very difficult to do everything right. It is very difficult to avoid recidivism or the perception of it. It's very difficult for you to, on the one hand, maintain gainful employment and meet all appointments, to be able to have the living that can keep you out of trouble and still be on the right side of the law with felony convictions and the like. So that was a case where it was a split sentence, if I'm remembering correctly. And then the other case that came later was one in which the leniency that I sought was a hard-fought battle. But ultimately, because I had preserved credibility, there was an opportunity for this person to have rehabilitation and treatment as the real cause and way to ensure that he was contributing to our society effectively. And, when you have moments to advocate, I think it can be surprising to judges and defense counsel alike, when at times you become the advocate of, this is not the instance where incarceration would be fruitful. And at times realizing that incarceration is a fool's errand is very difficult for a judge at times to reconcile, coming from a prosecutor.
I wanted to ask a question about sort of patterns and data. So you mentioned earlier, and I think you're right, that nobody gives you like a chart or a formula for how to handle individual cases. Are there any moments in which the office of a prosecutor looks back at a pattern? Like, for example, looks at all of the breaking and entering charges. And I picked that crime because it's one in which in a lot of jurisdictions, people might get a plea deal that would allow for probation only, but could also, depending on various factors, end up doing some prison time. Was there ever in your experience an effort to kind of look back and see how people fared based on the different kind of intervention, the different consequence, and to try to use that information going forward to take into account impact and consequences in deciding how to handle future cases?
Rarely did I follow the case as a reference of how to choose the next sentence, in the sense of how the person fared ultimately, mostly because the length of sentences would require you to look much more into the future and not have the data immediately available to compare and contrast. Also, the idea of the reasons why the person may have committed the crime, or what they call the crimogenic factors that might be involved in the sentencing report in interviews, and what their background was, may make them extraordinarily distinct from one another. And so the idea of, let me figure out sociologically how this person fared, to then use that as a litmus test or a guidepost for somebody else, was something that just was not pragmatic in the sense of the day-to-day work of the prosecutor. However, I did, in terms of drug courts, for example, that would be an instance when I would be able to use the data in terms of, hey, this is a person who fared quite well through the process of having the opportunity, and here's how drug court works, or here's how an anger management class, or here's what this person required because of substance abuse or domestic violence intervention programs, whatever it might be. Those were instances where that data was probably more readily available, at least as an option to pursue. And I think these courts that recognize that there need to be some off ramps from the traditional views of how punishment is doled out are based on that sociological data you're talking about, based on the idea of, look, the notion of locking someone up and throwing away the key is not how justice can operate for the overwhelming number of people who are going to return to society at some point. This notion of not giving people the tools they need or the opportunity for redemption just is not a practice. It's not a good approach to justice. And so there were those moments I could do that.
Yeah, it's really interesting. I think you're right, in my experience as a reporter, that drug courts or off ramps like mental health counseling, other kinds of diversion programs, they often have to justify themselves as alternatives by showing that they have better outcomes, that people are less likely to reoffend. Whereas I think systemically, we don't ask the same questions about jail and prison. We sort of default to them, but actually it's important to know what the outcomes from jail and prison are for reoffending as well, because one of the measures, I think, well, I don't know if you would agree with this. I would argue that one of the measures of success of a system is whether it's helping to keep people out of jail and prison and help make them more productive citizens, or at least not get in their way. But I think that your experience is typical, that usually prosecutors' offices are not super focused on this. And I just wonder, looking back, if you feel like this is an element of prosecution, or really of the court system as a whole, that's worth paying more attention to.
I think it is, but it's also the idea of thinking about who is in control and what the work of a prosecutor. I mean, you almost have the impression, I think people think, okay, well, from inception of the case through appeals, it's the same prosecutor. When in reality, there might be dozens of hands that have touched that file between the time that the case is brought in to the time that it's tried. the appeal is handed off. You might be consulted later on. Hey, I had a quick question. I'm in the appellate section. I have a quick question for you about this particular in the transcript. What was the point of this part? Okay, great, thanks, bye. And you are looking at your volume of cases, and there's this, obviously quest to be perfect, and there's no time to be. But then there's also the idea of the appetite for what you're talking about. I think that not everyone has the same notion that justice can be holistic and still have the volume of cases that need to be churned out. Just look at right now in our court of public opinion, as people are gauging and evaluating the pace at which people are charged from the January 6th insurrection. The idea of what's taking so long, you're contemplative to the point of being paralyzed. You should have 1,000 things by now. And oh, by the way, how come these people have not been charged? And you have, the Attorney General essentially being really tracking more likely what we do really, which is it's going to take the time it takes, whether that's a good answer for you or not. And the idea of methodically working through cases and thinking about the best way to allocate resources and your time and management. And I think sometimes it would shock people to know, the cases that for you might be horrific. I mean, pearl clutching. How can this case not be getting the book at it? And you think to yourself as you're sitting there in a day when the cops are coming by for what we call papering, and they're coming by and they're bringing you cases and telling you, here are all the people on the lockup list. These are all the people who are there right now. Here's what they did. And you're gauging whether you're going to charge a case or not, or dismiss the case outright and call it no paper. And people will walk in and say, well, oh my God, this person was, I've got a stabbing case, or I've got this violent assault. And real questions that prosecutors ask is, well, did it hit a major artery? Or how many stab wounds are we talking about? I've got this amount of cases. I've got this amount of prosecutors. Or you may charge a case and your prosecutor comes back and says, we charged this case. This person was punched in the nose. Is that it? Tell me something more. And people think, well, before you're a prosecutor, you think, well, that's a serious crime, or this amount of drugs, whatever it might be. And it's really sometimes comes down to this rejection of the pearl clutching, the rejection of, I'm glad that that's how you see the world. Let me tell you about the more serious crimes to which we have to devote more resources. And that's sort of a moment when you think about, so when you ask questions about, are you following cases along, or should we think more about what actually works and doesn't work? Yes. We should, as a society, be thinking about the purposes of our prison system and our incarceration. It's about retribution for some. It's about rehabilitation. It's about preventing recidivism. But oftentimes, inertia keeps everything in motion, even when our better selves know it should be revised.
Yes, I think that's a great point. Never underestimate the role of inertia in the criminal legal system, or maybe in our political system. I'm curious what you make of the movement in the last really like 5 or 6 years to elect local district attorneys and state's attorneys who identify as progressives. They run for office, often challenging someone who's like a traditional throw the book at them kind of prosecutor. They talk about shrinking the footprint of the criminal legal system, trying to have fewer people in prison. They decide not to prosecute marijuana offenses, for example. Sometimes they stop seeking very heavy sentences in most crimes. And since really 2016, they've won, candidates like this have won election all over the country in big cities, Chicago, Philadelphia, San Francisco, LA. Now the Manhattan District Attorney, Alvin Bragg, is a self-described progressive prosecutor. And as someone who was working in the US Attorney's Office handling cases day to day, what do you think it would be like to work for one of these folks?
In general, I think it would be a different experience to work for somebody who was elected, because you're beholden to the public in ways that even the political appointee is not. I mean, the political appointee as a US attorney obviously serves at the pleasure of the president. But I was a career prosecutor, so we did not think about the day-to-day or how our cases might impact a political party or impact somebody's tenure in office. And in a way that was very freeing to be able to know you could make decisions where you did not have to abide by a campaign promise and instead simply focus on your oath. On the same vein, though, I do believe that there are instances where prosecutorial priorities obviously are handed down or dictated, even if you don't have an elected official, even through a US attorney or through the Department of Justice. And I think it's important and valuable to really reflect on the best use of one's resources. I cannot overstate it enough to think about how there are so many limited resources, and there are ways in which we really need to, in a sense, prioritize the prosecution, not because everyone is not entitled to an advocate, but because you will have to make decisions that will seem at times unfair, seem at times quite callous, and seem at times that you are not in touch with what this individual victim feels, but that is perhaps going to serve society in a different way. These are tough choices to make. I often wonder, though, about whether the choices to, not prosecute, say, a resisting arrest charge versus one not wanting to prosecute small amounts of marijuana. These are qualitatively different decisions, and qualitatively different in terms of why. And I wonder if the decisions would, in terms of resisting arrest or more violent crimes or perceptions, will actually fuel further distrust between the community and officers. Will it make officers believe that they are more at risk, therefore they will be perhaps more inclined to act in a violent way? Will they be more hands-off, therefore perhaps safety concerns abound? But really, I think as a whole matter, Emily, we've got to stop thinking about this either or, that either you can be a proponent of civil rights or you can be a prosecutor. These two things are really not on different footings. They have to be together. How can you be a prosecutor and not think about the civil rights impacts on the person who you are seeking a conviction against? How do you objectively weigh and have a healthy level of skepticism towards an officer who brings you a case and not contemplate whether there are Fourth Amendment shortcomings and violations? How do you stand there and say, you know what? I'm the beneficiary of so many benefits of a doubt. I mean, just think how often people have said things like, well, the government, wouldn't have charged them if they didn't do something, or the officer didn't get up today to commit a crime, or we got to believe an officer. Because one of my first voir dire questions was always for a jury, would you give more weight to an officer's testimony by virtue of them being an officer? And across the board, people said, well, yeah, because they're a police officer, even if you knew conceptually how fallible human beings, let alone officers, can be. And so this idea of how do you have that approach and still be able to abide by the requirements to provide exculpatory information when the person doesn't have the resource of the federal government? How do you abide by that oath and those principles? I just look at it in terms of the mascot of the Department of Justice is a flawed one. I don't think we need to have somebody blindfolded. I think we need people who actually watches and sees what's going on, who actually understands the role of race and bias in our justice system and does more than just pretend, like the Supreme Court has tried to convey, that we're in a post-racial world, or that there's no reason to focus on these issues any longer. Why would the justice system be the one area where race suddenly has no impact? It made a right turn and avoided it all. And so I think that this notion of a progressive prosecutor versus maybe a conservative prosecutor, they all need to be invested in civil rights, and the outcome can be the same if you are thinking about it holistically.
I want to bring in a question from a reader, Trina Epps, and this, I think, is a good segue from your last answer. She asks, why are white and Black people sentenced differently for the exact same crime? This leaves Black people being sentenced for much longer and white people often being put on probation or not being put behind bars at all.
Well, sociologists have been studying this for a long time about the idea of how the race of the victim and the race of the defendant can sometimes dictate the outcome of whatever sentence that person has. And it's also, I think, because when you talk about juries and you talk about the ways in which people try to curate the justice system and the courtroom dynamics, is that we are well aware of how leniency can come about when you can see yourself in the other person, when there is some element of that could be me, or that could be my child, or that person made a mistake, or whatever it might be. You don't have people who tend to, if you feel a distinction or don't see yourself in that person, you're not really a jury of the peers, right? You're a jury of judgment, which it happens a lot more than we think. And I'll give you an example in just the real world that I think surprised so many people. And that was the jury trial and the conviction of the men who are convicted of killing Ahmaud Arbery, the young jogger in Georgia. And in the voir dire, the counsel for the defendant said they wanted more Bubbas. We got to have more. That was their word, not mine. We want more Bubbas on this jury. They don't want them college educated. And the thought was that if we had a jury of peers for the defendants and educational attainment, the race of the person that would go by the name Bubba, you have the stereotype conjured up in your mind, that they would share whatever bias these people had, or they would be able to see themselves not in the person who was jogging, but instead of the person who committed the crimes. And because of that in the voir dire process, that same sentiment can sometimes happen when the end result reflects a very different outcome. But it's the reason why it was so bold for the defense to even mention it is because of how effective a strategy like that has been over the course of American history. So, there are sociological reasons, historical reasons, but I think it comes down to that we see ourselves, if we see ourselves in the person, victim or defendant, we make judgment calls. And a lot of that seeing oneself is contingent on their relatability and oftentimes tied to race and gender and even occupation.
So, Laura, I wonder if young people who are going to law school or finishing law school, maybe especially women, maybe especially Black students, ask you for advice about what kind of legal career to pursue. You and I are both people who have taken our law degrees and gone in some other direction as journalists. And
have we run away?
I don't feel like we've run away. But my law school classmates enjoy mocking me for not maximizing my earned income potential all the time.
The golden handcuffs are overrated.
I am so with you. No, do not look back on that one. But I wonder what advice you have for students now, especially if they're interested in justice. Do you send them to the prosecutor's office? Do you send them to the Justice Department? Do you tell them to go fight for the rights of criminal defendants as defense lawyers? Do you say, you know what, you need to be a step removed from the system and trying to make systemic change a different way? What is your advice?
Well, first of all, as much as I critically evaluate my time at Justice, it was really an honor to be somebody representing the people of the United States of America. It really was an honor, from the voting section and beyond, particularly the voting section. And I can tell you, I'm always very clear that I want more people in positions of prosecution who believe in civil rights, whose lived experience should be considered and perspectives should be apparent. And that's because I want to disrupt this fallacy that Black and brown people in particular only should occupy one space in a criminal courtroom, and that is of the defendant or perhaps defense counsel. And one of the chapters in the book talks about this tension, this conversation between myself and the Black defense counsel, where we both were talking about who had the right seat at the table, so to speak. And she believed as defense counsel that she alone occupied that because she believed that there was an inherent level of civil rights integrity in the work she was doing. And I was the opposite. I believed that it was important to be in a proactive position where you could be both gatekeeper and exerciser of discretion. And also there was no point in asking for a seat at the table if you can only react to decisions that are made at that table. I wanted to make sure that people who looked like me and thought like I did were in positions of power, and not just complicit because they think that that's what you have to be in order to be this pigeonhole of a prosecutor. And I tell people all the time, women and women of color and everyone, frankly, unapologetically bring your entire self into what you are doing. Do not try to conform because you think that this is what a lawyer is supposed to look like or act like or be. or what a prosecutor is supposed to look like or act like or be, or whatever career you choose. You have to be there. There's a reason you are there, and we're better if you are there. I'm an emotional person. I write about in my book. I'm emotional. I feel very deeply. And I think some people, especially as a woman, they think that that's somehow going to be a form of weakness. It only strengthened my resolve. Being a mother, I found very transformational. I knew, my father said, welcome to motherhood, Laura. It's going to be like having my mother as well, it'll be like having your heart live outside of your body for the rest of your life. And that's what it feels like for my 2 children. It certainly does. But I became a better lawyer because I saw the world through a different level of empathy. I became better when I brought myself into the room. But there's also always, for me, this tension of, am I better, which ultimately left me to leave the Department of Justice with the idea of, am I better to work within the system or to work from outside of the system? And I think the combination of the two has served me well, to use truth telling and information as a form of activism. But before I could speak truth to power, I had to first know what the truth was. And so I encourage people to, on this journey with me, to vicariously experience and tell me what you would or should do differently, and then do it.
That brings me to my last question, I think, which I'm gonna steal from a reader, listener, hopefully watcher, Linda Bites in Chicago. She asks, what are the implications of doing this work within our country system, given the current political landscape?
Well, I think it's, frustrating to see the stalemate that we all have experienced and watched on Capitol Hill as it comes to, for example, the George Floyd Justice and Policing Act, where a lot of conversations were had about justice reform after that really powerful summer of what they were calling a racial reckoning. And I think it left some people with a bad taste in their mouth as they thought about what the work needed to be done, and it felt like an exercise in futility. Voting rights cases can feel very similar in terms of, how can this be a politicized issue? How can this concept of what is to be fair, how is that a partisan issue, right? And a nation of laws, how do you have that? And so I think that what we have to start looking at is sometimes I don't mean piecemeal in terms of patience. I mean, how do you eat an elephant? Sometimes one bite at a time. And there are ways to look at what are the successful aspects of different legislative acts. What are the high priorities? To me, if we focus on solely police interactions, you're missing a whole lot of aspects of our justice system that creates the types of injustices I saw and talk about. One is this issue of qualified immunity. It's a judicially created doctrine. And yet it has become such a hurdle for any civil litigation or a prosecutor to be able to do anything about it, and has not acted as an effective deterrent. The idea of the Graham versus Connor decision of the Supreme Court, where they created a standard that said, we're going to judge a police officer's actions by a reasonable officer standard as opposed to reasonable person standard. This has been a huge hurdle for prosecutors to even attempt to pursue prosecution. One of the exceptions was what happened in the Derek Chauvin trial, when you no longer had the hypothetical, here's what an officer would have done. You had officers who said, this is not what should have happened, and took the stand to do so. But that was quite extraordinary in the times we live in to do that, including Chief Arredondo taking the stand on this very notion. And of course, a videotape that transformed as the star witness the entire thing. But issues about the presumption of innocence, if we believe that, then why must we pay for it in the same way? Our bail and our bonds requirements in this country can be a financial padding of the wallet for jurisdictions, and can be the circumstance that makes people who are slapped with an allegation and a charge have to decide, I know I'm innocent, or I believe I can prove it, but do I have the money to prove it? All the way up to what Congress can be doing about maybe tying the federal power of the purse to requirements of dashboard cameras and the like, and databases, and talking about the power of unions. There's so many different factors, but I think what we often find ourselves doing is when people are talking about ways to reform our system, they think to themselves, you know what, I'm going to ask for, I'll ask for this. And then Congress people will say, couldn't give you that. Oops, never mind. Next thing, got to work on something else. Those off ramps can't be allowed. And I think we have to make sure people are aware that, look, all the way through the Bureau of Prisons, all the way through sentencing commissions and parole opportunities, justice is an ecosystem, and every single thing must be evaluated and possibly reformed.
What an incredibly rich, robust, vibrant conversation. I'm so grateful to both of you for being just such great partners in that conversation. Emily, of course, we never had any doubts about you, and Laura, not that we had doubts about you either, but
what
wow,
are you trying to say?
I'm not saying anything. And if it sounded like I said something, I didn't say that. I did not say that.
Lonnie likes like the tried and true. She just is making sure.
I'm not a sensitive person. I love you both. Thank you. I'm giving you a hard time. It's the prosecutor in me.
Oh, I'll take it. I could take it. I'm pretty thick that way. So I want to say a couple things. One, we're going to continue this conversation in after hours. You can jump in. You can ask Laura your own questions. This is going to be, I can already tell it's going to be a very sparky after hours, lots to discuss. Buy a copy of the book. Help it go up, 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 even higher on that bestseller list. Have it stick around on that bestseller list for weeks and weeks and weeks. That's what we want to see. So there's been links put in chat about how to buy it through our bookseller. Come join us in after hours, number one. Number two, we're at 7:57. So I'm going to jump in with one quick question. And it's one that's, I think people are probably curious about. Did you ever consider being a public defender, Laura? And if not, why not? And if so, why did you not pursue it?
I did not, because I wanted to be in a proactive position to exercise power, and not for the sake of exercising power, but for the sake of being able to ensure that the decisions that were made that would ultimately be looked at by a defense counsel, that there was an opportunity for justice to occur. And I just found myself, and there's a chapter about this very notion, but questioning, did I want to be in the position where the weight of the federal government, as unbearable as it can be, there was no viable recourse other than perhaps a flaw of the case, as opposed to in the inception, really being able to be a proactive gatekeeper and trying to honor people's rights.
I appreciate that. And then a question from Lucy. We didn't talk about voting rights, but I'm going to tuck it in here since you do obviously have a lot of professional experience with that. She asks, what can the average person, and maybe you can give us, we're down to 1 minute. What can the average person do to support and advocate for voting?
Vote to ensure that people who understand that voting rights is not a partisan issue. You're not guaranteed to vote for the winner, but you ought to have the ability to participate in the process. And I look for candidates who honor that philosophy of the one person, one vote. And I would not be, I would fight hard against pretextual reasons that are cures in search of a problem just to disenfranchise Black and brown people.
Perfect. All right, 8 o'clock, almost on the dot. Thank you so much, Emily. We'll see you in just a few minutes.